In 1957, a British court did something bosses still pretend cannot happen. It held an employer liable for the office prankster on his payroll. Since then, the case file on workplace jokes has only grown thicker. By fact number 14, you will hear about two captains whose silence about a single dinner cost their city $1.6 million. These are 25 office jokes that ended real friendships, real careers, and in several cases, real lives. 1. April 1st, 2012, an Intel manufacturing plant somewhere in the United States. A worker arrived for his shift in the same khakis he wore every Wednesday, expecting nothing in particular about his day. By morning break, a folded sheet of office paper on his back read, "Kick me," in black marker, and coworkers were already counting hits. They obliged that sign for hours, treating his ribs and calves like a polling station with a long line. He did not laugh, did not chase down the prankster, did not smile once. He filed a misdemeanor battery complaint with local police, and the prosecutor took the case seriously enough to charge it formally. Two coworkers lost their jobs at Intel that month and walked out of court with permanent battery convictions stamped onto their public records. The plant's friendly little April Fool's tradition died that afternoon. So did several friendships at Intel that day. 2. In August 2019, at Gravity Diagnostics in Covington, Kentucky, Kevin Burling had worked as a lab technician for 10 months. He had told his office manager months earlier that surprise birthday parties would trigger his anxiety disorder, citing a specific childhood reason. He had asked, on the record, that no one throw a celebration for him under any circumstance. They threw the celebration anyway. In the lunchroom, with the cake already cut and balloons taped above the door when he walked in. Burling spent the rest of his lunch hour breathing inside his parked car, alone in the parking lot. The next morning, supervisors lectured him for stealing his coworkers' joy, for missing the cake, for being ungrateful. They fired him within a week for being, in their exact words, possibly violent. A Kenton County jury awarded him $450,000. The friendship with that office manager never came back. 3. Filed in the United States District Court for the Eastern District of New York, the matter of an employee versus a Chucky doll. Deborah Jones had told her supervisor at an earlier corporate training event that she suffered from a serious doll phobia rooted in childhood. She mentioned specifically the murderous variety popularized by 1980s horror cinema. She also described, without any expectation that the disclosure would be weaponized, the medical conditions that worsened her startle response. Those conditions included a major depressive disorder and an autoimmune illness she managed daily. Her supervisor noted this carefully, returned to the office, and on the final week of her training presented her with a Chucky doll while laughing. Court filings allege the prank produced what they call a severe mental health crisis at her desk. Doctors confirmed PTSD, prescribed 2 months of medical leave, and watched her resign. Litigation is currently pending in federal court. 4. 2 armed Albuquerque police officers approaching a customer service counter, cuffs ready, on a Tuesday afternoon. The setting: the Southwest Airlines ticket counter at Albuquerque Sunport in August 2002, where Marcy Furschbach had just finished her probationary period. The officers told her quietly that an outstanding warrant existed in her name from another state. They cuffed her hands behind her back tightly in front of customers, co-workers, and one elderly traveler still holding her boarding pass. They walked her 15 feet toward an elevator while she cried. At the elevator, a supervisor jumped out and yelled, "Congratulations for being off probation," and everyone applauded. Furschbach kept crying through the applause. Supervisors sent her home. Southwest, which marketed itself for years as a fun-loving, spirited company, watched its onboarding tradition reach the 10th Circuit Court of Appeals. The friendship she had with that supervisor never recovered. 5. Panama City Beach, Florida, May 2001. The Hooters on Front Beach Road. Manager Jared Blair had announced an April beer sales contest with a single prize. The waitress with the highest beer count for the month would, he told them at staff briefing, win a brand new Toyota. As April progressed, Blair clarified the prize might be a car, truck, or van, and that the winner would pay her own registration fees. 26-year-old Jody Berry, working day and night shifts, sold the most beer by a comfortable margin. On a Friday evening, Blair blindfolded her and walked her to the Hooters parking lot, where co-workers gathered to watch the reveal. He removed the blindfold. Barry held a small green plastic figure of Yoda from Star Wars. While Blair laughed, only the lawsuit eventually delivered her a real Toyota. 6. The setup in a small office somewhere in the United States. A coworker thought it would be funny to place an open pair of metal scissors on his colleague's chair seat. The colleague had stepped to the kitchen for water. The prankster and another worker watched, grinning, as the colleague returned to his cubicle and sat down. The colleague felt a sudden sharp pressure in his thigh. He stood up, bleeding, with the scissors stuck through his pants and into his upper leg, 2 inches above the femoral artery. The medical bill came first, then the conversation about workers' compensation, then the realization that horseplay claims often fall outside coverage. The prankster had not intended for him to bleed onto the office carpet. The prankster had intended for him to laugh. The intent did not survive the puncture wound. Step back. Pause on what you have just heard. Every story above has the same shape. Someone said the prank was meant well. Someone walked away in cuffs or tears or a body cast, and the friendship that came in that morning never came back. 7. East Baton Rouge, Louisiana, August 9, 2013. A Men's Warehouse company picnic in Slidell. Loy Nguyen had been at the picnic, enjoying barbecue with coworkers from his store. He stood up briefly to refill his drink. When he returned to the bench, an unidentified colleague, referred to in court documents as John Q. Doe, because, of course, pulled the chair out from under him as Nguyen began to sit. Nguyen fell backwards, hit his head on the chair, then his body on the ground. He suffered injuries he claimed cost him wages and medical expenses. He filed suit on August 8, 2014, in the 24th Judicial District Court in Jefferson Parish, naming both the retailer and the unnamed prankster. The retailer is now permanently associated in legal databases with one missing chair. The friendship with John Q. Doe did not survive. 8. England, 1957. Hudson against Ridge Manufacturing Company Limited concerned the duty an employer owes its employees about a workplace prankster. The defendant company employed a factory worker known for years by colleagues and supervisors as a man who enjoyed pulling pranks of an increasingly physical kind. He had wrestled co-workers to the ground on prior occasions in front of supervisors with no consequence. Management had warned him repeatedly, written him up, watched him continue. He did not stop. On the day in question, he forced the claimant, Mr. Hudson, to the factory floor and broke Hudson's wrist clean. The Court of Assizes ruled, in proper formal language, that an employer who knowingly retains an unsafe employee remains liable for the foreseeable consequences. The pattern was already documented in the company's own files. The employer wrote the check to settle. 9. Scotland, 2010. Wilson against XL United Kingdom Limited. The supervisor at the XL depot was, formally, the person responsible for implementing the company's health and safety policies on the floor. His official duty was to keep employees safe. His chosen method on the day of the prank was to walk up behind a female employee and forcefully pull her head back by her hair. He called it horseplay. She called it an injury. The Court of Session in Scotland later examined whether an employer can be liable when its own designated safety supervisor causes the very injury he was paid to prevent. The court ruled that the supervisor had stepped briefly outside the scope of his employment to perform the prank. The depot kept its written safety policy on the wall. The friendship between supervisor and employee did not survive the yank. 10. Patel against Homerton University Hospital, NHS Foundation Trust, Central London County Court, 2017. A hospital worker had walked, hands full, toward her chair at the start of her shift. As she began to sit, a colleague pulled the chair out from beneath her. She fell hard onto the floor and sustained a spinal injury that altered her career path permanently. She sued the trust on the theory that the employer should be liable for the prank that took place inside its building during her shift by a fellow staff member. The court reviewed the legal definition of, quote, in the course of employment, end quote. The court concluded that the prankster had been acting in a purely private capacity, unconnected with his work. The trust paid nothing. The hospital, the chair, and the spine all stayed in the file. The friendship did not. 11. Milwaukee, 2016. A 4-story apartment building under maintenance. A maintenance crew on the upper porch had finished hauling out an old water heater, which now sat in the alley below. Someone in the crew suggested dropping a 170-pound refrigerator off the 4th-floor porch onto the heater for the sound. The crew pushed the fridge over the railing. A worker on the ground had jokingly volunteered moments earlier to catch it, but his phone had rung. He answered, walked, and stepped directly into the falling appliance's path. The fridge struck him in full and killed him within seconds. The OSHA file lists horseplay as a contributing factor in his death. The widow received survivor benefits. The crew lost a coworker, a job, and any version of the day they meant to have. 12. Citra Walker had been new to her job at a clothing store and wanted, on her first April Fool's Day, to bond with her boss. She thought a phone call might do it. She picked up the store phone, called her new boss directly, and reported that a robbery was in progress. The boss took her at her word. The store entered emergency protocol. Police arrived within minutes. By the time Walker explained the joke, dispatch had logged a felony-level call. The county prosecutor charged her, formally, with inducing panic. Her dream of an icebreaker bonded her, instead, to a criminal docket. Did she still have a friendly relationship with that boss after sentencing? 13. October 2004, Fire Station 5, Westchester area of Los Angeles. Captain John Tohill had purchased a can of dog food, in his own words, as a joke trophy for firefighter Tenny Pierce, who had nicknamed himself Big Dog during department volleyball. Firefighter Jorge Arevalo, with the captain's knowledge, mixed the dog food into the meat sauce of a spaghetti dinner intended for Pierce. Pierce, a black firefighter at a station with documented racial tension, took 3 bites before noticing his coworkers laughing. He filed an internal complaint. The department disciplined Arevalo with a 6-day suspension, the captains with 30 and 24 days for the cover-up. Pierce sued the city of Los Angeles for racial harassment. The city paid him $1.43 million to settle on the eve of trial. 3 co-workers, 1 dinner, 1 ended relationship. The bigger the entity, the bigger the check. The dog food in fact 13 ended 1 career and cost the city of Los Angeles $1.43 million. The cover-up by the captains who let it happen ended 2 more careers and cost the city another $1.6 million on top of the first. 14. 2007, Los Angeles Superior Court, the case of Burton and Tohill against the city of Los Angeles. Captains Chris Burton and John Tohill, both white, both supervisors at Fire Station 5 during the dog food dinner, had received the heaviest discipline of any LAFD employees connected to the prank. The Latino firefighter who slipped the dog food into the spaghetti served a 6-day suspension. The captains served 30 and 24 days. They argued in court that they had received harsher punishment because of their race. Their own attorney had hoped to settle for $250,000 each. The city's outside counsel turned down the offer. A jury then awarded them, jointly, $1.6 million in damages. The dinner that ended Pierce's career also ended theirs. Only the city paid for everyone's friendships. 15. 2007. The the Brenda Lee verdict at the Los Angeles Fire Department. Lee, a black lesbian firefighter at Station 96 in Chatsworth, alleged that colleagues had subjected her to a sustained pattern of pranks dressed as hazing. Among the items in her complaint, someone had mixed urine into her mouthwash. Other allegations included unsafe drills run without proper safety protocols and derogatory remarks tied to her race, gender, and orientation. A jury sided with her and awarded $6.2 million, the largest LAFD discrimination verdict to that date. The department, on receipt of her complaint, had declared her unfit for duty. A federal civil rights investigation later found a pattern of discrimination. An appeals court eventually reversed her award on procedural grounds. The mouthwash bottle remained in the file. 16. A Missouri construction site, OSHA file, ladder ascent, and a coworker on the ground. A worker was descending the ladder of a cement mixer at the end of his shift when his coworker, on the ground, decided to flip the bottom of the ladder upward as a joke. The worker fell several feet to the surface below. The medical record describes multiple ligament tears, a spinal disc injury, and a series of surgeries that followed. He received nearly $1 million in workers' compensation eventually. The coworker who flipped the ladder kept his job for a while, but not the friendship. OSHA categorized the incident in the official paperwork as horseplay-related. The two men do not speak. One walks with help. 17. The setup. Somewhere on a corporate Slack server, a disgruntled employee creates a fake email account designed to look exactly like human resources. He sends a mass message to every coworker on his floor. Each message contains an individualized list of grievances, framed as if HR had decided to forward them along, anonymously, in a kind of quote-unquote social experiment. Several recipients respond, hurt and confused. The IT team, alerted by the volume, traced the email to its actual source within hours. They identified the sender. They walked the printout to management. He was fired, escorted out, and remembered forever as the anonymous HR coward of the third floor. Who, exactly, did he think he was protecting himself from? 18. The 8th of January, 2019, the Pinellas County Sheriff's Office Administration Building in Largo, Florida. Lieutenant Joseph Garretts had received a package through interoffice mail and opened it at his desk. Inside the box, insulated with plastic packaging, sat a red cylindrical object with protruding wires, accompanied by a handwritten note that read, "Boom." Lieutenant Garretts, observing standard protocol, vacated the office and notified his superiors. The bomb-sniffing canine arrived. Sections of the building were evacuated. The Tampa Police Bomb Squad later determined the object presented no actual threat, but Florida statute treats hoax bombs as a second-degree felony, punishable by up to 15 years in prison. Deputy James Piper, age 59, with 35 years of service, admitted to mailing the package as a prank. He resigned the same day and was charged the next. 19. April 23, 2019. A Walmart in Richmond, Texas. A YouTuber named Lauren Love, with more than 100,000 subscribers, dressed up to look like a high-ranking Walmart manager and walked the aisles selecting employees on camera for fake termination. The video shows her praising some workers, then pivoting to others and informing them in a serious tone that they were fired. Most employees absorbed the joke. Maria Leones, a 6-year cashier originally from the Philippines, did not. Leones, a former professor in her home country, broke down on camera. She told the camera she felt powerless and small. The video collected more than 42,000 views before Walmart formally banned Love from every store and asked YouTube to remove the upload. Leones kept her job. The trust she had in random shoppers walking the floor never came back. The pattern is becoming visible. 3 of the next stories involve perpetrators who survived only because someone else arrived in time, with first aid, an extinguisher, an emergency room. The 4th one did not survive at all. The cases ahead crossed the legal line between mischief and manslaughter, between horseplay and a body bag. These are the cases where the friendship did not just end at the office door. These are the cases where one of the two people was no longer there to end it. 20. The setup, somewhere in a small office, told to a manager by the manager herself. A young employee had only worked at the company a few months when several of her coworkers decided to pull a prank that involved making her think the police were arresting her. They borrowed a uniform from a coworker's wife. They drafted a script. They executed the prank in the office, at her desk, in front of others. The young employee began to cry, then to vomit, then to call her family to arrange elder care because she believed her life was ending. The pranksters did not stop the prank when she cried. They did not stop when she vomited. They stopped when she stood to leave the building. The friendship did not survive. The young employee did not stay. 21. India, October 2023. A factory floor and a hose pressurized to industrial standard. A factory worker named Dayashankar Dubey was at his station when a coworker, in what was later described as horseplay, inserted an air compressor pipe into his rectum. The pressurized burst caused severe internal injuries. Dubey did not survive the trip to the hospital. His family filed a wrongful death complaint with police, and the case left the realm of workers' compensation and entered the realm of criminal negligence. Earlier that same year, in July, a 16-year-old boy died in a near-identical incident in another country. Compressed air at 12 pounds per square inch can dislodge an eyeball. At 40 pounds per square inch, it can rupture an eardrum. Used the way Dubey's coworker used it, the consequence is named clearly in the police file. 22. Boston, 1980. A local television station the morning of April 1st. A producer arranged a hoax broadcast in which Great Blue Hill, a familiar landmark south of the city, appeared on screen, erupting with flames and lava. State and civil defense lines lit up immediately as residents called in for evacuation guidance. The producer, who had expected some chuckles, watched switchboards melt instead. Authorities issued formal statements correcting the report within hours. The station fired the producer for poor judgment within days. The hill, of course, remained dormant. Only the careers around it caught fire. 23. Smith against Crosley Brothers, England, 1951. A similar workshop and a far darker prank. Two mechanics removed a colleague's trousers and inserted a rubber hose into his bottom. The hose was connected to a compressed air supply. The pressure caused serious internal injury. The injured worker brought a civil claim against the employer, arguing the company should bear vicarious liability for what its employees had done on company time and on company property. The court considered the relevant law on the scope of employment. The court concluded that an act of this kind, committed without warning by individual employees, could not have been reasonably anticipated by the employer. The Crosley brothers paid nothing. The two mechanics paid a loan. 24. The 1st of April, 1998. The morning radio show on a Boston FM station. The hosts, broadcasting live, announced that the mayor of Boston had been killed in a car accident. As is required of any prank, the joke needed a denial. The mayor, however, was on a flight at the time and unreachable by phone. The hosts spent several minutes selling the bit. Listeners called family members. Local news outlets scrambled to confirm. By the time the mayor's office could publicly correct the record, the rumor had reached every neighborhood in the city, and the network had filed termination paperwork on the hosts within 48 hours. Within months, a national network signed them to a syndicated show. The friendship between the two hosts and their old station did not survive, but their careers somehow multiplied. 25. The 11th of June, 2009, a bodywork repair shop in Gravely, Cambridgeshire, England. Paul Graham was working alongside his friend and coworker Peter Wilkinson when, according to multiple coworkers' testimony, Wilkinson sprayed the back of Graham's overalls with a highly inflammable thinning agent called gun wash. Wilkinson then asked another coworker in the canteen for a cigarette lighter. The coworker gave him one. Moments later, Graham was on fire. The fire began at his midriff and spread up to his shoulders before another worker put it out with an extinguisher. Graham has no memory of the incident. Wilkinson disappeared and never gave evidence at trial. The Court of Appeal ruled in 2015 that frolicsome but reckless conduct could not be said to have occurred in the course of employment. The friendship ended on the floor of that body shop. There is a phrase that judges keep using in these cases. They call the conduct frolicsome but reckless. It is a phrase designed in part to absolve employers of liability for what their employees do to one another for a laugh. It is also a phrase that names the precise problem this video is about. Frolicsome means lighthearted. Reckless means it could have killed someone. And sometimes did. The two words are sitting next to each other inside the same legal sentence because the law has watched, decade after decade, employees walk into work as friends and walk out as plaintiffs, defendants, or names on a marker. The dog food, the chair, the hose, the lighter, the Chucky doll, the Toyota, the kick me sign. Every one of them began with someone telling a coworker in their own head, "This is going to be hilarious." None of them ended that way. The thing that ended in every case was the friendship that came in to work that morning. Some employees really should stay home. If you have ever worked next to someone who likes to plan a prank, you already know which kind of employee they are. There is a follow button below this video for the next expose in this series. The next case file is already growing.